Good evening. And on a weekday, we thought why not have a session with a speaker like Adv.G.Karuppasamy Pandiyan, and to facilitate the very intricate topic on the intricacies of hostile witness, we had requested him, and we had also done a session with him on a solitary witness. So I think that people feel in the beyond law that he can be a witness to a good sessions where there is a different topic and different perspectives, especially on the criminal perspective of law. I request Karuppasamy to share his insights. Over to you.
Thank you so much, Mr. Vikas. This is my second session. I feel so honored to share my knowledge in this reputed forum. The topic which is assigned to me is nothing but intricacies on hostile witness. This topic is more popular in the side where the criminal practitioners are practicing. Hostile witness, this term, though it is unknown to the criminal law, but it is frequently and regularly using in the courts of law. And when we trace out what is meant by hostile witness and how the hostile witness can be proceeded with, the answer lies in section 154 and 155 of Evidence Act. And when we deal with the topic of hostile witness, and we must go into the other sections, namely 162 class 1 proviso class, and also section 280 CRPC. So these are all the 4 provisions which are playing in the field, in my view. And with the famous saying, I would start this. The true evidence, the person who is giving true evidence will be rewarded with an afterlife to the heaven. So the corollary is that perjury leads to hell. This is famous saying. With this, when we see the evidentiary value or evidence of hostile witness, we should bear in mind the famous legal maxim, falsus in uno, falsus in omnibus. This maxim, according to which false in one thing and false in everything. This maxim has no application in India. When we deal with the hostile witness and its evidentiary value, this maxim should have been bear in mind. The hostile witness, which can be loosely called as adverse witness, unfavorable witness, unwilling witness, but all these terms are known to English law, but it is unknown to Indian law. When we see the distinction between the English law and the Indian law with regard to hostile witness, insofar as the English law is concerned, a party is not permitted to impeach the credit of his own witness. But in India, it is otherwise. A party is permitted, with the permission of the court under section 154 and 155 of Evidence Act, he can question his own witness. This is what section 154 says. As per section 154 of Evidence Act, question by a party to his own witness. This is what the section starts. Here, I would read the provision for your convenience and for the better understanding, the court may, in its discretion, permit the person who calls a witness to put any question to him which might be in cross-examination by the adverse party. Here, any question, the terms assumes much importance, the term, because it has wider connotation. If the court permits, permission is sine qua non to put question when a witness is not favorable to the party who is calling him. This is the thing. Any question which means a party who can put any question to the witness calling by him. Here, any question, this is very, very important, only to cull out the truth. Any question can be put forth if it is in the name of cross-examination. So this is very, very important. And the second limb of section 154, that is 154 class 2, nothing in this section shall disentitle the person so permitted, subsection 1, to rely on any part of the evidence of such witness. So law is quite clear and it is no longer res integra in respect of appreciation of evidence of a hostile witness. Merely because a witness turned hostile, that evidence cannot be effaced off or passed off from the record. The portion which remains admissible, the portion which favors to the prosecution, that can be taken into consideration, and there is no legal bar to base conviction based on the part of the evidence. Because I already said, falsus in uno, falsus in omnibus is unknown to Indian criminal law. And the appreciation of hostile witness only will be arisen at the trial courts level. Trial judges are linchpin of the judiciary, because of the reason that they are in direct contact with the litigants and also the witnesses. Under section 280 of CRPC, demeanor of the witness has to be looked into. That is why the apex court time and again says the trial judge should not be a mute spectator and he must be an active umpire. This saying assumes significance here, because if a witness comes into the witness box and goes on against the party who calling him, even in the absence of a request made by the public prosecutor, the court by itself, that is the trial court by itself, can give permission to the public prosecutor to put questions only on seeing the demeanor of the witness and tone and tenor of the witness. So here the saying is assumes importance. And the first case law in this regard, which is reported in 1975 Supreme Court, AIR 1975, Supreme Court, page number 1400, Shagir Singh versus State of Delhi Administration. Though there is an earlier case law, but in respect of appreciation of evidence of hostile witness is concerned, from this judgment, the evidence of hostile witness kicks off its journey. The Honorable Apex Court in this judgment held that when a witness who has been called by the prosecution is permitted to be cross-examined on behalf of the prosecution, the result of that course being adopted is to discredit that witness altogether and not merely the Supreme Court said in 1975. According to the Supreme Court, the evidence of hostile witness, if it is permitted by the court to be declared as hostile, that wholesale rejection is permissible. That is what 1975 the Supreme Court held. However, the very next year, the Supreme Court took a departure. That is on 1976. AIR 1976 Supreme Court to 294. This is the very, very, very important judgment. This judgment still holds in the field. Sadbal versus Delhi administration. Sadbal versus Delhi administration. Here, the Honorable Supreme Court very categorically held in a criminal prosecution, when a witness is cross-examined and contradicted with the leave of the court by the party calling him, his evidence cannot, as a matter of law, be treated as passed off the record altogether. It is for the judge of fact to consider each case whether as a result of cross-examination and contradiction, or can be still believed in regard to a part of his testimony. So the earlier judgment was specifically overruled here in 1976. So this is the settled law still now. And based on this proposition, in section 154 class 2, that is class 2, which has been amended. This is the amendment provision where the 154 class 2, nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such witness. So this 154 class 2 born out of that proposition of law that was held in the year of 1976. And 155 is also very relevant because the impeaching credit of witness. The credit of a witness may be impeached in the following ways: by the adverse party or with the consent of the court by the party who calls him. Here, we have to see with the consent of the court by the party who calls him. If court permits the prosecutor to put questions, then in the light of section 155 of Evidence Act, the witness creditworthy can be impeached. So this is very, very important. And I would take all of you to see section 162 class 1, where the proviso class, it is very clear. The proviso class reads as, provided when any witness is called for the prosecution in such inquiry or trial, whose statement has been reduced into writing as aforesaid, any part of his statement, if duly proved, may be used by the accused, and here it is very important, with the permission of the court by the prosecution, to contradict such witness in the manner provided by section 145 of Evidence Act. To contradict his own witness, what is necessary? The permission of the court, consent of the court according to section 154 of Evidence Act. So this provision also plays in the field of dealing with the hostile witness. With this, the very proposition of law, still it is in the same line without any deviation so far. Recently, the Honorable Supreme Court, that is Constitution Bench, in Neeraj Datta case, Neeraj Datta versus, this is very recent judgment, (2023) 4 SEC page number 731, Neeraj Datta versus State NCT Delhi, 2023 4 SEC page number 731. Here, the Constitution Bench of the Supreme Court reiterated and upheld the view of Satpal Singh's case. And recently, the Supreme Court held there is no legal bar to raise a conviction upon a hostile witness testimony if corroborated by other reliable evidence. Further, the Constitution Bench has given a stamp of approval of the case, namely Satpal versus State of Delhi Administration. So this is very, very important. And declaring the witness as a hostile witness is not at the drop of hat. This is what Supreme Court held. Merely because a witness resides from his earlier statement. For that, a witness cannot be outrightly rejected or outrightly declared as hostile witness. This is what in Gura Singh versus State of Rajasthan, that is reported in AIR 2001, Supreme Court 330 page number, where the Supreme Court held declaring the witness as hostile is not at the drop of hat or for mere asking. And the famous English philosopher and jurist Jeremy Bentham, who says witness is ears and eyes of justice. That is what he labeled the witness. According to him, witnesses are eyes and ears of justice. By quoting this quote, in Best Bakery case, the Supreme Court held if the witness himself incapacitated from acting eyes and ears of justice, the trial gets paralyzed. And it would be no longer a fair trial. This is what the Supreme Court held in Zagira Habibullah case. This case is famously called as Best Bakery case. And one more proposition also I would like to state. A hostile witness need not necessarily be a false witness. Merely because declaration of a hostile witness cannot be branded as false witness. This is what Supreme Court held in 2015, 2 SEC page number 662, Selvaraj allies Chinna Payyan versus State of Tamil Nadu. This is very, very important case. And the one more famous judgment I would like to quote here. Rabindra Kumar De versus State of Orissa, AR 1977, Supreme Court, page number 170. In this case, the Supreme Court held merely because a witness speaks the truth, which may not suit the prosecution or which may be favorable to the accused, the discretion to allow the party concerned to cross-examine its own witness cannot be allowed. So what the Supreme Court time and again says, the 154, which gives suo motu power to the trial court, and that power is untrammeled one. So that power has to be exercised judiciously. Even the prosecution is not seeking permission. The court can, by using suo motu power, ask the prosecutor to put questions and to proceed with section 154 of Evidence Act. So this is very, very important. And in one case that is that was held by Madras High Court, that to division bench, Kannan alias Mannannai Kannan versus State, 2022, 1 MWN criminal, page number 327, where this case was handled by me. I was the counsel on record in this case. One counsel engaged me in a murder case. On seeing the papers, I got shocked. All the witnesses completely turned hostile, lock, stock, and barrel. Even then, trial court convicted the accused to the tune of life sentence. Appeal was preferred, and the trial court proceeded to convict the accused based on the repetition of 161 statement put forth by the prosecutor under the guise of cross-examination. Ultimately, the Honorable High Court, that is division bench, deprecated the practice of put forthing the 161 class 3 statement replica to the witness, and last only one suggestion as if the witness is deposing falsely. In this case, the Honorable High Court not only deprecated the practice of repeating the 161(3) statement, but also directed the state to conduct proper training program for the prosecution by engaging a senior criminal lawyers. So this is very, very important. Mere repeating the statement contained in 161 class 3 CRPC by the prosecutor under the pretext of cross-examination of witness could turn hostile can never be a substantive evidence, and it cannot be looked into. That is what the Honorable High Court held. And in the RK Day, in that case, one more proposition also emerged. The contingency of cross-examining the witness by a party calling him is an extraordinary phenomenon, and permission should be given only in special cases. That is what Supreme Court held. And further it is held, it may be rather difficult to lay down a rule of universal application as to when and in what circumstances the court will be entitled to exercise its discretion under section 154 of Indian Evidence Act. And the matter will largely depend upon the facts and circumstances of the case. This is what Supreme Court held. And one more judgment that was held earlier, that is in the year of 1964, by the full bench of the Supreme Court. Dayabai Chakanbai versus State of Gujarat, where the Supreme Court held the court therefore can permit the person who calls a witness to put question to him, which might be put in the cross-examination at any stage of the examination of witness, provided it takes care to give an opportunity to the accused to cross-examine him and answer elicited which do not find place in the examination in chief. Even when a witness turns hostile or goes unfavor, even at the stage of cross-examination, the prosecution can seek permission and confront his own witness in the light of section 154 of Evidence Act. And the Madras High Court in one judgment reiterated the proposition, that is Romer versus State, 2019, 1 MWN Criminal, page number 17, where the Honorable Madras High Court, that is Division Bench, held that witness turning hostile not a ground to prevent court from finding accused guilty if there is otherwise acceptable evidence in support of the prosecution case. So this is what the Supreme Court and also High Courts held in respect of appreciation of hostile witness. Though that term is unknown to criminal law, if any witness goes unfavor to the party who calls him, he can seek permission from the court and confront that witness. In the name of confrontation, the party can put any questions to call out the truth. Here, the appreciation of evidence rule is very, very important. And in respect of appreciation of evidence is concerned, the only one famous judgment we should bear in mind, especially in criminal side, Vadivelu Thevar versus State of Madras. This is reported in 1957 AIR, Supreme Court, page number 614, where the Supreme Court issued a guideline how to appreciate the evidence in a criminal case or in a criminal trial. There is 3 guidelines. One is wholly reliable. Second is wholly unreliable. For these 2 guidelines are concerned, there is no difficulty at all. If the evidence of the particular witness is wholly reliable, the court can rely upon and proceed to convict. And the second guideline is concerned, the evidence of that particular witness is wholly unreliable. Here also no difficulty. The court can simply discard and proceed to acquit. The third category, this is very, very important, where the trial courts are tasked. When a witness and its evidence neither wholly reliable nor wholly unreliable, Here the task is started. What the Supreme Court in that particular case held, the courts has to see the corroboration. The courts has to seek corroboration from the other independent sources and proceed with. Here also this proposition applicable. If the hostile witness tenders evidence which partially looks credible or seems to be reliable, that can be corroborated with the other evidence and the court can proceed to base conviction. So in the realm of appreciation of evidence, the evidence of hostile witness assumes some significance, and merely because a witness turns hostile or being unfavored, there cannot be any wholesale rejection. The part which favors to the prosecution and the part which favors to the defense can be taken into consideration. This is what the earlier Supreme Court says, judgment says, and to that effect, section 155 class 2 also very candidly amended. And in respect of the evidence of hostile witness, if the prosecution is not seeking permission to declare hostile, what would be the effect? A witness very categorically confirms the prosecution case in chief. However, in cross-examination, that witness goes diametrically opposite and suit the defense case. This being the situation in which what the court has to do, the Supreme Court, even in the year of 2010 answered in one judgment, Javed Masood versus State of Rajasthan. In that case, the Supreme Court very categorically held witnesses not supporting the prosecution case, but supporting defense. However, witness not declared hostile. There is nothing in law that precludes the defense to rely on that evidence. So the portion which suit the defense case can be relied upon because there is no interdict in the act, that is Evidence Act. So this is the outline of the evidence of hostile witness. And now let us have the interaction. Because sir,
yeah, there was some power failure, so the host had changed.
okay, no problem. Let us have the interaction session. Any question comes in this regard?
I don't think there is any question. I will just check it out on the YouTube because people are more watching on the YouTube.
Okay.
Except one, Vinod Kumar has written, "You are our beloved mentor."
Yes, sir.
Except for one, Vinod Kumar has written that you are our beloved mentor.
Oh.
Yeah.
Okay, you can put any question with regard to this.
Can we rely partly on the testimony of a witness before he is declared hostile after he has been declared?
Yes, if the witness is declared hostile, even the part which favors to the prosecution or the defense, that can be taken into consideration. Merely because a witness is declared hostile, there cannot be any wholesale rejection. This is the settled law.
Yeah. So, thank you, Karuppasamy, for sharing your knowledge. And on a weekday, it was quite that people are watching a lot on the YouTube. Thank you for sharing your knowledge. Thank you.
Thank you so much.
Thank you
So much.